Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. Today I wanted to talk to you about Virginia assaults and specifically what kind of discovery you can and should expect when you are charged with an assault here in Virginia. And before we begin, just a request to you all, if you're watching this video, you find value in it, or a friend or family member finds value in it, make sure to like and subscribe, trying to reach as many people as possible so they're aware of the tools and resources that we're putting out. So with that, let's begin. So this video is about what kind of discovery you can expect in your Virginia assault case. Just a caveat, in Virginia, an assault, what we're really talking about here is an assault and battery, both the actual touching of somebody without consent, as well as an act done in an overt manner meant to place somebody in fear for their safety, and that act is completed. We've done videos specifically on what the definition of assault and battery is, so I'd encourage you to look through our videos for that. This is really, if you are charged, what information, and by discovery, what information you should expect in your case. Just a caveat, every case is different. The facts of every case is different. There are certain rules in place, particularly with discovery, where one scenario you may get everything you need. Another scenario, you may need your attorney to file a discovery motion because the Commonwealth isn't giving you what you need. So this video is for informational purposes, really to help give you a guidepost and help you ask better questions of the attorney you ultimately hire. So the first question you should be asking yourself is, what is discovery? And discovery is essentially the information that you're entitled to or have a right to or are going to have access to when you are charged with a crime that helps you prepare for the allegations against you. When you think about it another way, you are discovering the case against you. To be clear, prior to 2019, 2020, Virginia had very limited discovery in assault cases, in domestic assault and simple assault and battery cases. It truly was a trial by fire in many instances where I, as the attorney, would show up with my client, have the best information I could possibly have based upon the information that client had provided me. And just before court, asked witnesses questions. And a lot of times we're finding out a lot of information as trial has happened. In 2019, 2020 timeframe, a lot was happening, as we all know. We all lived through it. One of the positive byproducts of that era was a real push for criminal justice reform, having a fairer system. Tragically, George Floyd was murdered. I think that raised a lot of awareness, that compelled a lot of change. And I think that trickled down to states, and particularly here in Virginia. And ultimately, we had expanded discovery rules that really benefited the process for both the criminal accused, but honestly, a lot of times providing this information by the Commonwealth, by the prosecutor, I think is beneficial for the prosecution as well, because if everybody has all the information, they know what's going to be presented at trial, we can make better decisions about our cases. Sometimes that may mean that an accused takes a plea because they didn't know that there were certain risks that were presented or that would be presented at trial, and that would end up shortening a docket, for instance. It also is the accused either allows us, especially in cases where our clients are maintaining innocence, to properly defend at trial, to mitigate outcomes, or sometimes to be able to advise our clients and for the accused to be aware of the risks presented and to allow them to make more meaningful, more knowledgeable decisions about their own case. Just from a technical standpoint, in Virginia, discovery in the criminal sense, in the criminal world, is governed by rules of the Supreme Court. So these aren't technically statutes, but they're rules authored by the Supreme Court of Virginia, which is our highest court. And so for cases originating in the general district or juvenile and domestic relations courts, and assaults are typically misdemeanors. They are assault and battery at the time that we're talking about is misdemeanor. They are governed by Virginia Supreme Court Rule 7C:5. And then for cases up in the circuit court, misdemeanors that are brought by direct indictment, they are governed by Supreme Court Rule 3A:11. Also, we do need to discuss Brady evidence. And what Brady evidence really is information that would tend to show that the accused is not innocent, exculpatory information, or to mitigate punishment. So this is required by the Constitution as well as a case called Brady, as you might imagine. So essentially, the Commonwealth has the burden or the onus to disclose information that may be hurtful to their case, that shows that the accused is innocent or should not be punished as significantly as they are claiming, or would tend to mitigate. So that's a broad requirement. We oftentimes, as accused defense attorneys, have to rely on the Commonwealth to understand what Brady is. If for some reason we believe that they're violating Brady, we have to file a separate Brady motion. So that's another part of discovery that's not in the Supreme Court, but it is required both from a legal standpoint, but I also think an ethical standpoint for Commonwealth attorneys, prosecutors here in Virginia to be aware of the Brady obligations. And oftentimes, unfortunately, they violate those intentionally or not. And so that can be detrimental to their case, but also it can lead to very, very serious implications. So if you are a prosecutor that happens to be watching this video, learn your Brady obligations. It's best for everybody involved. As I stated before, most of these cases, if you are charged with an assault and battery, domestic assault, simple assault, they will originate in either the general district court or the juvenile and domestic relations court. Those are the lowest trial courts for criminal cases in Virginia. You have the general district court. If things don't go well and you want to appeal it, you have an automatic right to appeal de novo to the circuit court, which is the highest trial court in Virginia. If you don't like the result there, you also then have legal avenues to appeal legal decisions, and those go to the Court of Appeals and then the Supreme Court of Virginia. So once you're in the Court of Appeals, Supreme Court, you don't get new trials. The appellate courts are reviewing the records from the circuit court, but those are obviously very important to be aware of. Hopefully, in your assault case, you're not having to go that route because that means that you didn't get the outcome that you wanted. But just be aware that those are also options. But again, if you are charged with a misdemeanor assault and battery here in Virginia, it's typically going to start in the general district court or the JDR. The difference in the JDR versus general district court is the relationship between the accused defendant versus the complaining witness, alleged victim. Family members are for the juvenile and domestic relations court, whether it's actually married spouses or former spouses, people with children in common, siblings, that mothers and fathers, that kind of thing. Whereas in general district court, and sorry, that should have been GDC, not GCD. That was a typo on my part. That's between individuals that don't have any prior relationship or not at least blood relationship. To be clear, if you actually pull the statute, the rules, Rule 3:11 dealing with cases in the circuit court is much broader than the rules of discovery in the general district court governed by 7C:5. And in fact, 7C:5 only requires that the accused, upon a request, be permitted to his or her own confessions and his or her own criminal records. So it's very narrow, but in circuit court, it's much broader by the rules. But what I will say, at least here in Northern Virginia where I practice, that's Arlington, Alexandria, Fairfax, Loudoun, the Commonwealth attorneys, Prince William, are typically giving broader discovery than they're required to by the rules, which is a very good thing. I think they do it because it benefits everybody to a certain extent. But unfortunately, many of them will require you to sign protective orders, orders of agreement of reciprocal discovery, meaning you're giving them discovery as well. I don't like that, but oftentimes when you look at the cost versus the benefit, if you're an accused, I oftentimes are recommending that you agree to signing proposed discovery plans by the Commonwealth's attorney, because typically you're going to get much more information that you would be required by the rules of the Supreme Court, at least in the General District Court. Changes when you get to the Circuit Court, but at least in the General District Court. So what should you expect? And by what I mean by that is, what information should you expect to see before you're going to court for your assault case? So usually you'll get police reports. And what is a police report? A police report is essentially after an officer makes an arrest, they will go into their computer system and type up a report documenting what they observed, what they heard, what they witnessed, witness statements, witness information, and you will typically get a version of a police report. Many times that police report will be redacted with sensitive information, for instance, witness contact information, alleged victim contact information. But usually you get a substance, the substance of those reports, so you can understand what they are documenting, what they are alleging they witnessed law enforcement. In addition to that, most jurisdictions here in Northern Virginia, law enforcement will be wearing body cam video or body camera. So you will have access to body cam. And what a body cam is, if you were arrested or questioned by law enforcement, you probably or may not have noticed it was even happening. But usually law enforcement will have essentially a camera position on their chest that will actually be videotaping everything that's happening. And typically what will happen is, and I think by their local requirements, they will turn it on as things are happening. So when I get these body cam videos, you'll see law enforcement driving up, and then as soon as they get out of the car, usually 30 seconds later, they'll pop on the audio so you can actually see what they're seeing. You can hear what they're hearing. And why does that matter? Well, it matters because oftentimes these videos will allow me to see exactly what my own client, the accused, said to law enforcement. So I know exactly whether or not they made a confession or admission that can be very important to knowing what I think they should do in their case. Oftentimes I will be able to see that what witnesses stated about what happened. Oftentimes you'll be able to see if there's alleged injuries, visible injuries, and whether or not the officer is taking photographs of those injuries. Many times you'll even be able to see what law enforcement are saying to each other. So let's say there are two law enforcement officers questioning an alleged victim or an accused. Then they'll step outside and they'll start talking to each other, and you'll get to hear what they're saying and thinking. I've had many cases where the law enforcement officers will go back and forth between each other, whether or not they think they have enough evidence for convicting somebody of an assault, or whether or not there's a legitimate self-defense claim, or, hey, we need to ask this question or clarify that issue. So that can be very, very insightful, even if it's not admissible in court necessarily. Maybe it is or not. But it's very useful in me assessing the evidence against my client and whether or not I think we should go to trial or take a plea, what the risk is at trial. Do I think they're going to get jail time, that kind of thing. Photographs of injuries. Usually, if there is an alleged injury from an assault, we will be provided photographs of those. That's super useful, because if somebody's saying that they were severely injured and then you see barely a mark on their wrist, or no injury at all, or an old bruise, that is very useful for me to analyze the facts against them. And then, as we talked before, Brady evidence, evidence that tends to show, to exculpate you, or to mitigate sentencing against you or punishment against you. And again, if I, for whatever reason, think that there's additional exculpatory evidence that the Commonwealth is not providing, I typically will file a Brady motion. In some jurisdictions, I actually put on a separate motion and put in there also ordering Brady. Sometimes they get annoyed by that because they claim, well, they already knew that, but I'd rather just have everything above board. And as I just mentioned, if we believe, based upon the information that I'm seeing, based upon what you're telling me, if let's say I'm representing you, I think there's more information, we'll put on a separate motion. So when should you expect it? Meaning, when should you expect a discovery? Usually your attorney will file a request with the Commonwealth's attorney. Sometimes it's actually filed with the court. And usually there's a deadline on there, whether it's 2 weeks before trial, sometimes more, sometimes less, depending on the timing. I will tell you, in most domestic assault and simple assault cases I handle in most Northern Virginia jurisdictions, I usually get discovery a couple weeks before court, sometimes much sooner, depending on the flow of the case, but usually a few weeks before court. That oftentimes will frustrate people because they want to know exactly what's happening with their case and when. But I'll tell you, at least in the cases I handle, I try to get that information to the client as soon as possible because I'm curious as well, and I want to start talking to them about their case. Once we get the discovery, at least here at Abarino Law, we will reach out to our clients. If there's video, we will arrange a time for us to watch it together if they want. If there's photographs, I will want to show that to them. I want to talk to them about what the reports are showing. I don't typically give the discovery to my clients because many times there's agreements with Commonwealth in order for me to get that information. I'm not allowed to just disseminate to them that information to them. Many jurisdictions don't want or want an agreement that we're not going to publish it on YouTube or Twitter or whatever. And unless I think that's needed, I don't usually fight that because frankly, both myself and my client would prefer that information to not be in the public realm because it's embarrassing enough. So, and as I said, we'll let you review it. Now, one caveat, and I tell this at least for cases we're handling, you have to be patient. A lot of times, we don't even get discovery until relatively close to court. Even if we do, most times we're not working out deals with the prosecutor if there's a deal to be made until the day of court, because in most jurisdictions or in many jurisdictions, the prosecutor is not talking to complaining witnesses and other witnesses because they don't usually talk to them until court or near to court. And the reality is that I don't think they're being malicious in this. They just have a lot of cases, and it's hard to be juggling all those witnesses. And a lot of times as you get to court or getting close to court, that's when everybody starts paying attention, witnesses start returning phone calls, or if you go to court, it's the time to get everybody in the room together. So you as the accused, you're going to have to be as comfortable as you can about that. That's how it operates. Oftentimes I'll tell you as a defense attorney, that's usually to our benefit because that means that the prosecutor's paying a lot less attention on a case than I typically will. So we're going to be way more prepared than they would. If we need more time, we usually can get a continuance, meaning we can get a postponement of the court date. If things go terribly wrong, and we also have an automatic right to appeal to the circuit court, as I mentioned before. So it is not the end all be all. Now, that being said, I get it. You're facing something. Most of my clients are facing something they've never faced before. And so I can only imagine how stressful that is. But again, this is a slow process, relatively slow. And I'll tell you, for purposes of how cases process, civil versus criminal, these assault cases are lightning speed relative to civil cases, which can take years and years. So just be aware of that. If you have questions, make sure you can comment below. You can send us a message. You can reach out to us. Make sure to subscribe to this channel. Like I said, we try to do our best to educate the public about Virginia criminal and civil law. We try to also have on local leaders and other interesting people to talk about Virginia criminal and civil law. I wish you guys the best. Make sure to check out